On to our next agenda item, how does the privacy rule apply to me? Plain and simple, the privacy rule is all about confidentiality and covers the information for a long time. Different states set length of time that health records have to be retained for, but this is only the minimum. If a covered entity chooses to retain these records longer, the privacy rule will apply until 50 years after the patient has died. Health record retention for the state of Vermont is 10 years. New York is 6 years after discharge for adults, or 6 years after discharge, or 3 years after the patient reaches the age of 18, whichever is longer, for minors, and 6 years after the date of death for deceased patients. New Hampshire is 7 years after discharge for adults, or 7 years after discharge or until the minor reaches age 19, whichever is longer, for minors. But remember, HIPAA still applies even if the state retention period has passed. Best practice says that if you can access it, or if you are storing it, it's protected under HIPAA. There are some instances when the privacy rule requires disclosure. There are only 2, but for these 2 we would have to make the disclosure. Those are to the individual to whom the PHI pertains when a request has been made by the individual or their legal representative, and to the Department of Health and Human Services if they are performing an investigation. There are other instances where HIPAA expressly permits the use or disclosure of PHI. We aren't required to make the disclosure, but absent a covered entity or UVM policy or safeguard prohibiting it, it would be allowed. These are to the individual when the disclosure is not otherwise required, for treatment, payment, or healthcare operations, otherwise known as TPO, when the individual has been given the opportunity to agree or object to the disclosure, when the disclosure is incidental to an otherwise permitted use and disclosure, for the benefit of public health or public interest, and when it is a limited data set for the purpose of research, public health, or healthcare operations. All of these are allowable disclosures and may be okay. The emphasis is on the may. It's important to keep in mind that individual covered entities may have policies or safeguards in place related to these disclosures, and you should always verify that it is allowable and that it is part of your job duties to make the disclosure prior to doing so. For example, it may be allowable for us to make a disclosure to law enforcement, but it also may not be. It is your responsibility to check to see if the disclosure is allowed before just doing it. Most of what you do on a day-to-day basis is going to be allowed under what is referred to as the TPO exceptions. HIPAA allows you to access, use, and disclose PHI for treatment, payment, and healthcare operations. When receiving PHI, we are responsible for it from the moment it was received. When disclosing it, we are responsible from the moment it is sent to the moment it was received. We are further responsible to only disclose PHI for TPO and only to those who need it for their own TPO. The need for individual privacy needs to be balanced with the need to provide healthcare, and ultimately, this is what the TPO provisions set out to do. Certain information has to be shared in order to treat patients appropriately. HIPAA also has what is called the minimum necessary standard. This is an important concept to understand as it applies to everything you do with PHI. It is based on the practice that PHI should not be accessed, it should not be used, and it should not be disclosed when it is not necessary to satisfy a particular purpose or carry out a function. The minimum necessary standard requires covered entities to evaluate their practices and enhance safeguards as needed to limit unnecessary or inappropriate access to and disclosure of PHI. The minimum necessary standard does not apply to disclosures to or requests by a healthcare provider for treatment purposes, disclosures to the individual who is the subject of the information, uses or disclosures made pursuant to an authorization, uses or disclosures required for compliance with HIPAA, disclosures to the Department of Health and Human Services when disclosure is required under the privacy rule for enforcement purposes, and other uses and disclosures as required by law. For any of these uses or disclosures, with the exception of those to or by a healthcare provider for treatment, you should check the policies of the covered entity or with your supervisor to make sure you are authorized to use or disclose the PHI unless you have already been expressly authorized to perform the function. Disclosures can also be made to friends and family when it is clear that they are involved in the care of the patient. Because many reported violations are when PHI is disclosed to friends, family, and other acquaintances, it's important to be cautious in these situations. To avoid a violation, to honor the confidentiality of the patient, and to protect yourself, remember the minimum necessary standard. Remember to make sure the disclosure is part of your job and that you are authorized to make that disclosure. Remember that some test results may not be understood by the patients or their friends or family members, and that consultation with a provider is probably needed. Therefore, unless disclosing this is part of your job, you're going to want to refer the friend or family member to their provider for that information. If the patient or their legal representative has asked that information not be shared, or that information only be shared under specific conditions, there may be additional restrictions. There are some instances when the privacy rule only allows the use or disclosure when the patient has authorized it. We all have the responsibility to make sure that PHI isn't accessed, used, or disclosed unless it's allowed under the privacy rule or we have obtained authorization from the patient. Outside of that, don't access it, use it, or disclose it. Doing so could expose UVM and you individually to fines and penalties. As a business associate, you may be servicing multiple providers in multiple locations. Under HIPAA, you are required to abide by the policies of the covered entity as well as the policies of your own employer. The covered entity is required to set up safeguards, and you are required to comply with those safeguards. Some of what you do may involve de-identified information. Whenever possible, this is preferred. PHI that has been de-identified is no longer considered PHI and therefore not covered under HIPAA. The trick is making sure that it truly is de-identified. There are 18 identifiers that need to be completely removed, and the chance of re-identification would have to be so low that it's impossible in order for PHI to truly be de-identified. If you ever want to know whether or not PHI is truly de-identified, request a consultation from the Chief Privacy Officer by emailing privacy@uvm.edu. You have now reached the end of this agenda item. Up next, how does the security rule apply to me?